Okay, I think it's just after 7:05, so I think that we will commence. Good evening, everybody, and thank you for joining us online for the 16th of our British Association for Romantic Studies digital events. My name is Dr. Paul Stevens, and I serve as the Early Career Representative on the BARS Committee. I'll also be chairing tonight's event, where our four wonderful panelists will explore and illuminate new directions in romantic literature and law. Tonight's roundtable will chart new directions in romantic textual engagements with law, justice, and juridical discourse. Moving beyond established approaches to theorising the disciplinary relationship between law and literature, the presenters draw on a range of disciplines, including legal and social history, legal theory, media and gender studies, to offer a rich and nuanced account of the complex relationships between literature and law in the Romantic era. Taking the interplay of legal and fictional narratives as a common thread, these papers attend to law as a creative impulse, a subject for interrogation, and a regulatory paradigm. Before I introduce our panelists this evening, I'd just like to quickly thank the organisers of tonight's event, the BARS Digital Events Committee, Amanda Blake-Davis, Francesca Killeran, Anna Mercer, and Matthew Sangster. I would also just like to politely remind everyone to ensure that their microphones are muted during the presentations, and also that tonight's event is being recorded and will be made available on the BARS YouTube channel. And in the course of events, I would invite you to make use of the chat box to discuss ideas throughout the event. The structure of tonight's event will be familiar to those who have attended similar events in the recent past. The event will last for approximately 90 minutes. I will first introduce the panel, who will then each present a paper for around 12 to 15 minutes each. This will then be followed by 10 to 15 minutes of discussion between our panelists, and then at around about 8 o'clock UK time, we'll open the floor to audience questions for the remaining half hour of the event. And again, to pose your questions during this time, please use the raise hand function or use the chat box. So without further ado, I'm absolutely delighted to welcome tonight our four wonderful panelists, and I will introduce them in the order in which they will be presenting their papers to us this evening. Our first presenter is Dr. Allison Daniel. Dr. Daniel completed her PhD at the English Department of the University of Southampton in 2020. Her research explored how married women of the long 18th century experienced coverture and the ways in which female-authored fiction of the same period engaged with and reimagined those experiences. She was co-convener of the cross-disciplinary Adventurous Wives Conference in May 2021 and a 2021 Chawton House Fellow. She is a qualified barrister and practiced for a number of years in divorce and family law. She has also lectured in law at UCL. She is currently working as the Academic Skills Officer for the Widening Participation and Social Mobility Department at the University of Southampton. Our second speaker this evening is Dr. Sarah Ailwood. Dr. Ailwood is Senior Lecturer in the School of Law at the University of Wollongong, Australia. She researches at the intersection of law, literature, feminist theory and history, with a particular focus on the 18th century and Romantic period. She is the author of Jane Austen's Men, She is the author of Jane Austen's Men, Rewriting Masculinity in the Romantic Era, which was published by Routledge in 2020, and has contributed essays on Austen to the Routledge Companion to Jane Austen in 2021, and Jane Austen and Critical Theory, also 2021. Her current research explores women's legal memoirs and the 18th century origins of feminist jurisprudence and how women's voices are listened and responded to in the #MeToo movement.
Oh, Paul, you've just muted by accident, I think.
My apologies. I'll recommence. Our third speaker this evening is Dr. Amy Clarke. Dr. Clarke is an associate lecturer at the Open University. She completed her PhD in history at the University of Southampton, entitled Female Dishonour, Transgression and Celebrity in 18th Century England, circa 1750 to 1790. She also holds an MA in 18th century studies and a BA in English literature, also from the University of Southampton. Her research is centred around the phenomenon of transgressive celebrity, the relationship between gender and ideology in lived realities, and the conception of selfhood in the second half of the 18th century. And our fourth and final speaker this evening is Dr. Melissa Ganz. Dr. Ganz is an Associate Professor of English at Marquette University and the 2021-22 Lawrence S. Rockefeller Visiting Faculty Fellow at the Center for Human Values at Princeton. She works on 18th and 19th century British literature and culture, with a particular focus on the relationship between literature, law, and ethics. Her book, Public Vows, Fictions of Marriage in the English Enlightenment, published by the University of Virginia Press in 2019, argues for the centrality of nuptial law in early fiction and of novels to nuptial regulation. She has also published on legal and ethical dimension of texts by authors such as Jane Austen, George Eliot, Henry James, and Robert Louis Stevenson. Her current projects include a study of British fiction and penal reform from circa 1700 to 1830, from which her talk today is drawn. So it's my great pleasure to introduce this evening the first of our speakers, Dr. Allison Daniel, and the title of her presentation is The Disappearing Woman, Disrupting Coverture in Frances Burney's The Wanderer. Thank you.
Thank you. I now begin the process of sharing my screen. There we go. Can everybody see a PowerPoint? Yes. Oh, brilliant. Thank you, Paul. Thank you, Paul. So thank you for that wonderful introduction, and also thank you to Bars for having us, and finally thank you to Sarah for bringing the panel together. I'm delighted to be here this evening, and what I would like to do with this paper is to first of all give you a wider context for my research, and then I will go on to explore The Wanderer in more depth to suggest ways in which Burney, in common with some of her predecessors and her contemporaries, used her fictions to explore and/or disrupt some of the restrictions that were imposed upon married women at the time. Just to explain a little bit about my research background, this paper is drawn from the final chapter of my doctoral research, and my thesis combined legal theory, historical research, including primary historical research for each chapter, with literary analysis. And it analysed coverture as it related to women's land ownership, their ownership of goods and chattels, with specific reference to the marriage portion, which I will be talking about later, the marital relationship, and finally, wives' paid labour. The literary texts that I used came from the entire length of the long 18th century and included The Prude, Betsy Thoughtless, some short fictions from The Female Spectator, and Mary and Maria by Mary Wollstonecraft, and The Wanderer. The central contention of my thesis was that an understanding of coverture needs to be placed at the heart of 18th century female-authored marriage and courtship fiction. Coverture was essentially an inextricable part of the female experience of marriage, and in order to truly understand texts which deal with courtship and matrimony, its presence has to be acknowledged. Further, Female writers who were writing about coverture from a female perspective were arguably engaged in a very subversive action. Male and female experiences of coverture were irreconcilably different, although there were grey areas within coverture that women could and did exploit. It was a legal doctrine that was fundamentally designed to empower and enrich men and oppress women. Therefore, when women novelists wrote about it from a female point of view, their descriptions and their depictions necessarily differed from the normative male perspective. And this difference of perspective, as has been argued very persuasively by Paula Backscheider, created a textual space which could then be used to question and criticize dominant orthodoxies. Further, because the novel is a site where legal subjects were being debated, I also argued that novels themselves essentially became legal texts. So I was arguing, if you like, for a relocation of the law from its traditional sources, such as judgments or law books, to instead to occupy sites which reflect the actions of society. So what was coverture? Essentially, coverture was a doctrine of common law which sought, amongst other things, to regulate the legal and economic personalities of wives, both in relation to their husbands and to the wider world. During her marriage, a wife lost her legal identity as an individual who was separate from her husband. She had no power, for example, to enter into debts or contracts in her own name, and all her personal property, including her money, passed for good into her husband's control. Even if her husband died, unless he left her personal property in his will, it did not return to her. However, coverture, as I hope to demonstrate, is a bit of a slippery fish. And to ensure its existence, the ways in which it has been rationalized and explained changed throughout the centuries as understandings of marriage and as society itself changed. So even within specific time frames or specific settings, what coverture meant and how it applied are very elastic and sometimes contradictory ideas. However, during the latter half of the 18th century, which is where we are chronologically situated this evening, the story that coverture told about itself was powerfully encapsulated by William Blackstone's explanation in, I can't for some reason move my PowerPoint on, oh, hold on. Is it best encapsulated in William Blackstone's commentaries on the laws of England? And in particular, it centered on the idea of the unity of persons. Apologies. So the economic and legal consequences of coverture were also purported to be a fair exchange. So we basically are going to be dealing with three ideas here. The first is that we have the unity of persons, that husband and wife are one person and the husband is that person. Secondly, that there is a fair exchange, and Blackstone argued that because the husband basically took on all the risks of the marriage, he had to provide financially for the wife, he was answerable for all her debts, therefore he should benefit from her resources and her money. That was part of the exchange. And he also argued that not only was it intended to benefit the wife and benefit the husband, but essentially it was a condition which wives agreed to. Wives freely entered into this setup, so they couldn't really criticize it. So what does this have to do with Burney? How does Burney go about analysing, thinking about coverture and incorporating coverture into her writing? Well, Burney's interest in marriage and matrimonial law has long been noted, including very persuasively by my roundtable colleague, Melissa Ganz. However, I would argue that there are still issues specifically relating to coverture, which are waiting to be discussed in terms of her fiction. Now, these can help us understand Burney as somebody who, as Melissa has argued, could be very conservative when it comes to the legal requirements of matrimony, but I would suggest is more radical in terms of what level of agency or power wives should have within the marriage relationship. And this is where I argue that Blackstonian coverture is particularly relevant. Now, one of the images within Blackstonian coverture, as we've already discussed, is that of the disappearing wife, the idea of the unity of husband and wife represented solely by the husband. And there are a number of elements in The Wanderer, red flags, if you will, which I argue indicate that coverture means that coverture was within Burney's sights. Now, these include 3 separate examples of wifely disappearance, each occurring at different points in time, which function as a sort of extended metaphor. Now, the first of these happens in the past, and it's Juliet's mother. Her experience of marriage, albeit on French soil and strictly beyond the reach of English coverture, is to vanish. Firstly, through her husband's failure to acknowledge their marriage to his family, and finally through her death. The second disappearance is present in Juliet's flight from France and her subsequent existence in England incognita. Although it is Juliet's decision to leave France, she does so as a direct consequence of her marriage to the commissary. And finally, in order for her to avoid recapture, it is necessary that she disguises her identity. This causes her true self to remain hidden from those around her and brings with it consequences in how others perceive her and the agency she is able to exert over her situation. The third and final disappearance is located in the future. It is that which will occur if Lord Denmeath's plans to purge Juliet from her blood family come to pass. If this happens, Juliet will effectively cease to exist as a person within her own lineage, vanishing entirely into her married state, just as the £6,000 portion with which she is synonymous throughout the novel will vanish forever into her husband's control. By escaping to England, Juliet is not only attempting to avoid her own personal disappearance, but is also seeking to prevent her erasure from her own family history and rescue the memory of her mother from oblivion. But as well as demonstrating the abuses that occur when women vanish into marriage, Burney also uses Juliet's fight against her own disappearance to argue that this should not be an inevitable consequence of matrimony. Although Juliet faces challenges and difficulties, she is depicted as being able to work, to perform, to think, reason, emote, manage her finances, travel, conduct relationships with others, just as if she were single. This is also one of the reasons why the economic work plot in the novel is so important. Secondly, there is the Blackstonian fiction of free and fair exchange, and this is seen through the metaphor of the portion and how it is used to represent the female protagonist. This is a key metaphor, and it is used throughout the 18th century by writers from Ailwood through to Wollstonecraft, and I would argue Austen, as well as Burney. However, this needs not to just be read as a simple equation, women equal cash, or even women equal male property, but I would suggest it as a more subtle metaphor which invokes specifically what happens to women's personal property upon marriage, i.e. it disappears into the husband's control forever. And the types of suitors in these novels who value the marriage portion, they usually also seek to control or possess the woman absolutely, just as they would her money under the rules of coverture. This is not fair exchange, this is oppression. The true hero, in contrast, loves the heroine first and foremost for who she is. Her value lies in her unique self and what she as an individual will bring to the marriage partnership. And I would argue this also occurs in the case of Elizabeth and Darcy, for example, in Pride and Prejudice. Now, this is in keeping with a literary tradition. And Harley in The Wanderer recognizes and falls in love with Juliet for who she really is. Even before he knows who she is, he falls in love with her true self. And the coverture that she will experience during her marriage to Harley will not be one where she disappears. Instead, it will be one where she is valued as a unique individual, and it is her presence in that partnership as a unique individual which brings and enriches that marital partnership. There will be a marriage settlement, undoubtedly, but that is not why he marries her. Now, this may not be an equal marriage as it is understood in the 21st century, but I would argue that in the context of early 19th century images of wifehood, and particularly Blackstonian coverture, this is potentially quite subversive and radical. It disrupts the Blackstonian idea of financial exchange, and it empowers the woman within the marital relationship. Now, there are a number of legal ambiguities presented by the text, which could potentially challenge some of the conclusions. So I feel bound to deal very briefly with these. The first is, was Juliet actually married in France? And secondly, if she was, would coverture attach to her on English soil? Now, Juliet's French marriage is part of a pattern within the text that sets up a number of binary and contradictory truths. So she's both aristocratic and she is of commercial stock. She works for a living. She is repulsed by payment. She is also married and not married. She is a kind of Schrodinger's wife in that sense. So on a strict legal level, of course, this is nonsense. One cannot be a little bit married or half married. You either are married or you're not. And I would suggest that on the evidence within the text, her French marriage does not appear to be legally binding. And I would also argue that it goes against the letter and the spirit of revolutionary marriage, which required an exchange of vows. And you must remember that Juliet remained silent during her marriage ceremony in France. However, Burney still requires the execution of Juliet's supposed husband before she is truly free to marry Harley. So I would conclude, therefore, that even if we are being encouraged, that we are rather being encouraged to consider Juliet on some level as being a wife, even if a very strict legal analysis of the situation might not conclude the same thing. So there is also the issue of whether or not coverture would technically attach to the marriages referenced in the novel, given that Juliet's marriage and that of her mother occurred in France. Now, to this, I would say that Burney would not be the first author to use English law in a foreign setting for artistic purposes. And I would suggest that Anne Radcliffe, for example, does just this and uses the rules of coverture and also primogeniture relating to real property to explain the ill treatment of Madame Charon by Montoni in The Mysteries of Udolpho. So to conclude, Juliet's experience of coverture in her two marriages is radically different. She is symbolically extinguished as an individual in the first, but exists as a contributor of value in the second. Once coverture is explicitly factored into our reading of the text, the novel can be interpreted as Burney conservatively accepting the provisions relating to marriage regulation in England, as Melissa points out, but simultaneously seeking to disrupt the oppressive Blackstonian model of coverture. Thank you.
Thank you, Alison. I thought that was a fascinating paper. It was I sort of really like the sort of connections you were drawing out between sort of coverture and erasure, that idea of unity of persons in the sort of the marriage relationship. I thought that was a sort of fascinating set of ideas and a really fantastic way of introducing some of the topics I think we'll be discussing with the audience in due course. Thank you. Our second presenter is Sarah, who and the title of Sarah's paper is Jane Austen, Romanticism and Feminist Jurisprudence, if I've pronounced that correctly. I've been practicing that all afternoon and I think I probably still got it wrong. Over to you, Sarah. Thank you very much.
Which screen are you seeing? Sorry. Okay, hopefully that's working. Okay, thank you so much for the opportunity to present. My paper this morning is, as Paul said, looking at Austen and feminist jurisprudence. And this is really the beginning of a fairly new project that I'm working on, in which I'm tracing the relationship between Romanticism and feminist legal philosophy. And in this paper, I'm going to briefly situate this question in relation to accepted ways of thinking about the history of feminist jurisprudence, and then turn to what I see as two key threads of Romantic feminist legal philosophy that remain pertinent today, which is the critique of the public-private dichotomy and the valuing of the ethic of care and its relationship to citizenship. And then I'll briefly turn to look at how, like at a high level, how I see these themes playing out in Austen's Pride and Prejudice and Emma. Okay, so it's widely accepted in the legal academy that feminist jurisprudence or feminist legal theory originated in the 1970s, particularly with the entry of women as legal scholars into the academy. And this view has been expressed as recently as 2018 by the eminent feminist legal scholar Robin West, who writes, feminist jurisprudence, understood largely as scholarship on issues pertaining to gender equality, was launched in the 1970s, endures today and continues to shape debate. Earlier this year, Tracy Thomas revised this account and dated feminist legal theory very specifically to Women's Rights Convention in Seneca Falls, New York State in 1848, where she writes, the foundations of feminist legal theory were first established in 1848 and developed over the course of the next 150 years. And I could not help but wonder whether there might be an earlier Romantic generation of feminist legal thinkers and philosophers who I would not claim to be the first feminist legal philosophers, but who certainly predate each of these accounts of the origins and development of feminist legal theory. And I don't have a definitive answer to that yet, but I'm hypothesising that everything is pointing to yes. So even at the beginning of this inquiry, it's apparent that Romantic women writers' identification, analysis, critique and theorisation of law and its relationship to women's subordination is rich, crossing multiple genres and political persuasions, and that it also embodies many of the complexities, conflicts and contradictions that have endured within feminist legal philosophy into the 21st century. And one of the challenges that arises here for me is to distinguish between legal theory and political theory. We already know that several Romantic women writers are keenly interested in political theory. So I have adopted West's definition to investigate whether and how Romantic women writers were in search of a theoretical understanding of the relation of law to women's subordination, or more simply, between law and patriarchy. And framed through this lens, two threads of argument may be traced in Romantic women's analysis of law and patriarchy, which remain pressing and unresolved. The first is law's role in creating and sustaining the public-private dichotomy that lies at the heart of liberalism, which in the Romantic era was used to formally exclude women from civic and economic participation, as Alison has just been discussing, and in the modern era continues to justify the state's unwillingness to address problems that it continues to regard as private, the most pernicious of these being violence against women. The second thread of argument relates to the valuing of care and its conceptualisation as an alternative path to citizenship, an issue which has become more acutely present in the context of the COVID-19 pandemic. Both these threads of argument contain with them debate and disagreement. The breakdown of the public-private dichotomy is sometimes critiqued as tinkering at the edges of an inherently broken system and confounding the necessary rewriting of the substance and process of law and legal institutions that's needed for women's authentic participation in the public sphere. The ethic of care is criticised for doing nothing more than seeking to attribute value to the rules that women have been allocated within the patriarchy. Both these threads of argument and debates within them are evident in work by 18th century and Romantic women, including Catherine Macaulay, Mary Wollstonecraft, Priscilla Wakefield, among others. But rather than delve into the ways in which I see Romantic women writers engaging with this, today I would like to focus on interpreting Austen as an example of imaginative literature through the lens of feminist jurisprudence. and acknowledging that these issues are yet to be resolved even 200 years later can offer, I think, a more nuanced approach to reading romantic texts through a feminist jurisprudential lens. The interplay of the public-private dichotomy on the one hand and the valuing of the ethic of care on the other can be traced in Austen's novels. Read through a feminist jurisprudential lens, the courtship plots of Austen's novels conclude with the inevitable and brutal annihilation of the heroine's legal personhood and claim to the limited forms of legal subjectivity that are available to her as femme sole when she marries the male protagonist and becomes femme cavere. Although Austen clearly critiques law's privileging of the patrilineal inheritance of property, placing primogeniture and its consequences for both men and women at the centre of her novels, she does not explicitly critique coverture itself and the suspension of her heroine's legal personhood upon their marriages, although now that I have heard Alison's thoughts on the idea of proportion, I need to go back and revisit that thought. Yet from in this apparent absence of critical engagement with coverture itself, Austen explicitly critiques both public-private dichotomy and celebrates the ethic of care. So I want to start with Pride and Prejudice, and to truncate sort of my analysis today, I want to focus very specifically on one passage with which I think many people will be familiar, which is that moment where Elizabeth realises that Darcy is an appropriate husband for her at the moment when Lydia's elopement seems to confound the possibility of their marriage. Elizabeth reflects that if she were to marry Darcy, she would gain the benefit of his judgment, information, and knowledge of the world, qualities gendered as masculine that supposedly qualified men for action within the public sphere and which were honed by men through their activity as public and civic agents. The supposed lack of such qualities in women justified their confinement to the private sphere, their exclusion from civic participation, and the suspension of their legal personhood during marriage. And in this passage, Austen does not really dispute that Elizabeth lacks these qualities. Instead, she draws their readers' attention to their absence, even in a woman who embodies the burgeoning desire for feminine agency, typical of the Romantic era. It's apparent from Darcy's intellect, education, conversation, love of reading, commitment to self-improvement, work ethic, and status within his community that he is a self-sufficient, driven, powerful, and respected operator. As a young gentlewoman of limited means and few, if any, socially acceptable paths to intellectual or professional advancement, marrying Darcy is arguably Elizabeth's best opportunity to develop the knowledge and understanding she needs for meaningful engagement with a world of ideas beyond the domestic realm. And this, Austen makes clear, is a benefit of greater importance because in Darcy, Elizabeth has found someone for whom she is willing to trade her status as femme sole, because what she will gain from him is worth more than the sacrifice of a form of legal personhood that brings it with it so few rights in terms of educational, professional, economic, or civic opportunities. Elizabeth's reflection that he is exactly the man who in disposition and talents would most suit her arises further, not only from what he can offer her, but his willingness to offer it. Elizabeth harbours no doubt that he will share his judgment, information, and knowledge of the world with her. And based on the honesty and authenticity of their relationship, she has no reason to doubt that. So Austen stakes a claim for women's engagement in the public sphere, not by demanding access to it, but by transforming the marriage relationship itself. I'm now going to turn to look at the ethic of care in Emma. So read through the lens of feminist jurisprudence, I think a single vital question hangs over Emma, and that is Emma a true citizen of Highbury? And this phrase, a true citizen of Highbury, is first used by Frank Churchill when he comes across Ford's on a walk through Highbury with Emma, where he says, "If it not be inconvenient to you, pray let us go in, that I may prove myself to belong to the place, to be a true citizen of Highbury. I must buy something at Ford's, it will be taking out my freedom." Frank here explicitly links citizenship and the notion of a municipal honour to the exertion of economic power. And although this connection is often interpreted as signalling Frank's shallowness, such a reading overlooks the close relationship between citizenship and economic participation within the public sphere that underpinned the emergence of the market economy in the 18th century, with which Austen is clearly engaging, and which continues to dominate liberal ideology in the 21st. Austen contrasts this male natural person whose legal personhood is unassailable with those less able to engage as economic citizens, femme sole whose economic power is curtailed through their lack of educational and professional opportunities, such as Miss Bates, and femme cavere whose economic citizenship is paradoxically courted by the market economy, yet denied by a legal framework that suspends their legal personhood and therefore their capacity to own property, retain income and contract in their own name, such as Isabella Knightley, Mrs. Weston, Mrs. Elton, and eventually Emma Knightley. If citizenship is framed through the market economy, then can Emma Knightley be a true citizen of Highbury? Yet participation in the market is not, of course, the only avenue to citizenship Austen constructs in Emma. The presence of the state is palpable as Austen fosters a specifically English sensibility by contrasting England with its others. As an extensive landowner, George Knightley possesses both voting rights and eligibility to stand for Parliament, as well as being a magistrate. Emma Woodhouse, by contrast, possesses no such rights, even were she to remain femme sole and inherit half of the Hartfield estate. If citizenship is framed as political participation, can either Emma Woodhouse or Emma Knightley be a true citizen of Highbury? In short, the answer to this question is no. Yet in Emma, Austen proposes a third pathway to citizenship, an alternative, arguably feminised model grounded in the ethic of care. If the market and the state are most present in Emma among all of Austen's novels, so too is the caring economy, that little recognised or valued by either the market or the state, underpins the human flourishing and the social cohesion on which both depend. Emma pays charitable visits to the poor and the sick in her parish, facilitates sociability for local women, is a devoted and energetic aunt, and reaches out to the unhappy and afflicted. Emma does not always enjoy these tasks, and her execution of them is far from perfect, but her devotion to her caring responsibilities is beyond dispute. Above all, Emma demonstrates an unassailable ethic of care towards her father, for which she is prepared to suspend her own personal happiness. Emma is the pinnacle of the caring economy, but does that make her a true citizen of Highbury? Emma's path to citizenship, like Elizabeth's path to the public sphere, is dependent on her choice of husband. Through Mr. Knightley's decision to leave Donwell Abbey and move to Hartfield to facilitate their marriage, Austen elevates the ethic of care to the same level as conventional conceptualizations of civic engagement, if not beyond, arguably advocating an alternative approach. Emma, moreover, does not enjoy a monopoly on care within the novel, as Austen emphasises the care Mr. Knightley takes of his tenants, of the local community, the Bates family, Mr. Woodhouse, and Emma herself. Whereas in Pride and Prejudice, the breakdown in the public-private dichotomy begins with a husband who recognises that his wife has an intellectual and moral stake in the public sphere. In Emma, that breakdown occurs through the investment of the values of the private within the public realm. So just to wrap up, there are clear threads of argument relating to the public-private dichotomy and to the ethic of care, including the conflict and complexity within those arguments that can be traced from the Romantic era to the present. Read through a lens of feminist jurisprudence, or reading through a lens of feminist jurisprudence, is a search for women writers' engagement with the relationship between law and patriarchy, and we should not expect that engagement to be neat, straightforward, or even necessarily coherent. Because the romantics, like us, the romantic women writers, were addressing a wicked problem and investigating how they approached it illuminates more connections, I think, between the Romantic era and the present.
Thank you, Sarah. That was a fantastic talk. I really liked the way that you took that one phrase, a true citizen of Highbury, and absolutely sort of unpacked it for us and sort of drew our attention to the sort of the legal assumptions and implications of what might seem like a short throwaway phrase. I thought that was really fantastic, a really enriching reading of the significance of that line. Thank you very much.
Thank you.
We turn now to Dr. Amy Clarke, and the title of Amy's paper is The Heroine's Defence, Narratives of Seduction and Wifely Duty in the Language of Excuse.
Thank you very much, Paul, for introducing me. I'm going to If you bear with me for a minute while I also attempt to do the share screen to show everyone my slides. If you could just let me know if you're able to see those, that would be brilliant. Yeah, all working, great, fantastic. Yeah, so thank you very much for having me here today. It's a real honour to be here and to be on a panel with such excellent other speakers as well. So my aim with this paper today is basically to introduce you to some of the concepts that I've been exploring in my research. And I'm going to illustrate them with just a couple of examples from one of my favourite case studies, who is a woman that was indicted for murder in 1775. So I'm working a little bit earlier perhaps than some of the other people on this panel. But she was able to move away from this accusation of murder to become a celebrated icon of the feminine ideal. In my research, I'm interested specifically in female agency within the courtroom, and also the role of storytelling and of reputation in criminal legal disputes. This paper is adapted from a chapter of my doctoral thesis, the central arguments of which were that several women attained wide-scale public attention during the late 18th century for criminal offences, and they were able to leverage this attention outside of the courtroom in order to manipulate their reputation and their sentences within the courtroom. My work explores criminal celebrity and various forms of female agency within this somewhat nebulous term. In relation to the subject of this paper and the argument that I'm going to be introducing here, my work is particularly interested in the interplay between fictional narrative tropes and defendants' courtroom testimony and their presentation in the courtroom. I view the courtroom itself as a kind of theatrical space to which the audience, both in terms of the broader public who would be reading reports of the trial, and also to the all-male jury and the judge, brought already formed narrative associations and expectations of character. And in this view of the courtroom as a kind of theatrical space, I'm very much building on the work of Dana Rabin, Ingrid Teig, and Swala Liviuri as well. As a defendant's character is an essential factor when determining guilt or innocence, or the degree of either, the ability to manipulate the expectations and social biases of their so-called audience was incredibly advantageous. In particular, for women who were publicly dishonoured by these accusations, and their defences often took advantage of the narrative trends and expectations of female characters in sentimental and romantic literature. It's easy to view the importance of female virtue as absolutely paramount when judging women's behaviour, particularly among the genteel in 18th century society. In popular novels throughout the period, such as those by Samuel Richardson, Fanny Burney, and Jane Austen, we're often given multiple examples where the fates of female characters are linked to their chastity and their associated reputation. The motif of an innocent maiden guarding her virginity was a powerful image of the female ideal at this time, the most potent sign of a woman's honour, and a device frequently used in literature to engender sympathy and admiration for the woman who does this. It was also used as a warning. The seduction narrative was frequently employed at the beginning of a narrative about a woman's downfall, making the link that once seduced and sexually ruined, bad conduct and a lowered social position was the obvious conclusion. Conduct literature, social commentary, and novels made the same claims. Virtuous women are rewarded with advantageous marriages and riches, and women of bad character are connected with unseemly or unchaste behaviour, and they often have bad ends. We have only to think of Fanny Price guarding herself against the advances of Henry Crawford compared to Maria Bertram's conduct in Mansfield Park, or the dangers to and later narrative rewards granted to Fanny Burney's Evelina, to see that throughout the second half of the long 18th century, approval of a woman's character often hinged upon her sexual conduct and her ability to vouchsafe her virginity and virtue. I'd like to explore some of the complications and the contradictions of this ideology, and also explore the ways in which female virtue was displayed and claimed by individuals even as they presented themselves as the subject of a seduction narrative and were accused of that most unfeminine crime, murder. In the summer of 1775, Jane Butterfield was indicted for the murder of William Scowan. William Scowan was a landed gentleman in Surrey, a younger son of the merchant, politician and governor of the Bank of England, Sir Thomas Scowan, and uncle to the politician and MP James Scowan. The Scowan family owned the Carshalton Park estate, with land extending through the area, and Scowan had also inherited a specific portion of this land at Woodcote Lodge. The first published accounts of the purported crime came after the inquest into Scowan's death. The Inquisition on Monday the 10th of July 1775 concluded that Scowan had been murdered by poison. After this indictment, reports of Butterfield's relationship with William Scowan were used to tarnish Jane Butterfield's reputation before the trial, and these then formed the foundation of the prosecution's accusations against her. The Middlesex Journal alluded that she was Scowan's mistress, and other papers associated her with a suspicion of immoral maidservants who had been connected with theft, prostitution, and the seduction of rich heirs in Daniel Defoe's Everybody's Business is Nobody's Business. Jane Butterfield had been named as the primary beneficiary in Scowan's will until suspicion arose from him and his surgeon that she was poisoning him. And then in the final weeks of his life, he wrote her out of his will and he moved to stay at his surgeon, Mr. Sanksley's home, and denied Butterfield from visiting him and burned her letters. She was even accused of murdering Mr. Scowan so that she could run away with her purported lover, Captain Moss, who had an agreement with Scowan that he would marry Butterfield upon the older man's death. On the eve of the trial, there was much speculation that she was in fact the exemplar of immoral femininity, her sexual appetite mirrored by her greed for wealth. Even the supposed method of murder, the fact that she'd poisoned supposedly Scowan's food as she fed it to him, was read as a corruption of caring wifely duty and the household she had been placed in charge of. In these first accounts, Jane Butterfield's appearance was closely examined for indications of her character, the reports structured for public entertainment within narrative tropes, and they bestowed a kind of detective power on their readership, encouraging readings of the physical self as indications of the inner character. Yet despite this inauspicious beginning, she utilised the image of the ideal wife and the narrative of virtue in peril to cleanse her character and to recover her reputation. In the absence of any definitive evidence that Scowan had absolutely been poisoned, and that if he had been, that she was the only plausible suspect, she was able to defend herself through the imagery of a dutiful woman who had to be innocent because she simply didn't seem like the kind of woman anyone could imagine to commit such a crime. Jane Butterfield's authorial hand in the construction of her public persona is quite difficult to see at times. There are no clearly published accounts by her, and when she spoke in public, she gave the majority of her statement over to others to read. Her case can only be read and pieced together through the newspaper reports, the trial transcript, the published letters, magazine articles, and pamphlets that presented her behaviour and her history. Yet Butterfield's lack of overt publication does not preclude her in self-authoring efforts. In her dress, her performative conduct at her trial, including her physical displays of feminine weakness and of high emotion, and in her subsequent pursuit of further compensation and the settlement of Scowan's estate to be left to her, Butterfield's personal choices in self-presentation and her desire to manipulate public favour to her advantage are visible. When it came time for Butterfield to present her own defence statement, she delivered what was later viewed as the most impactful piece of evidence and the theatrical highlight of her trial. She provided a demurely written account, and she said that she was too distraught to deliver it herself, so a clerk read it aloud instead. With it, Butterfield presented herself as a character from sentimental fiction, in which she presented herself as the threatened heroine of a seduction narrative. Her statement demonstrates her awareness of the elements of her appearance and of her behaviour that might be viewed as signs of guilt in the courtroom, and she countered each of these in turn from the opening, allowing her character to be developed through a lengthy narrative defence, as if through one of the first-person novels of sensibility or a theatrical monologue. Having her statement read for her also enabled Butterfield to distance her performative display of a submissive character from the forthright defence of her innocence, which could have been associated with cunning and deception. Despite the potential performative oddity of a male clerk reading the first-person narrative of a sentimental heroine's history, reports following the trial focused solely on the emotional impact of Butterfield's display of emotion and of the sympathy that it aroused in the listeners, and there's no record of the clerk's own influence over the reception of the piece or how he chose to deliver it. Butterfield's account of how she came to live with Scowan reads as a condensed novel, with her seduction by a rake and her destroyed reputation resulting in the loss of family and of the male protection of her father. So I quote here from her statement. At the age of 14, I became first acquainted with the deceased Mr. Scowan by the means of one of my own sex, through whom he was introduced to me. My mind was then unpractised in vice, and scarce acquainted with its name, but youth and innocence were no protection against the arts practised by Mr. Scowan and his female accomplice. and I fell victim to those arts at a time of life when I was as little able to foresee their consequences as to resist the attempt effectually. My seduction became immediately known to my father, who set his face against me, and whose death it was said, and I fear with too much truth, to have hastened. With the death of her father, Butterfield was left up to the ideologically and narratively predetermined fall into prostitution or life as a mistress. As she argued herself in the statement, "In this situation, what could I do? To rely upon the promises of my undoer afforded some shelter. To retreat from him and throw myself naked and defenceless upon the world was a step, in my judgment at that time, pregnant with greater mischief, if not my utter ruin." The choice before her here, she argues, as popular fiction indicated, was either to become Scowan's mistress or to make her own way, likely venturing into prostitution to survive. In choosing the former, and then by raising herself to the position of respect, where she was even considered by the community as Mrs. Scowan, Butterfield drew a connection between her seduction and traditional courtship before marriage. She also flipped the narrative expectations on their head, positioning herself as the heroine who wins a respectable marriage at the end of a novel through her own virtuous character, rather than as the ruined victim of seduction. Butterfield then presented herself as the ideological purifier and moral redeemer of the household, converting Scowan from his life of seduction. She cited her sentimental display of grief for her father as the catalyst for this transformation. And again, I quote, "The loss of my parent under those circumstances touched me most sensibly. The late Mr. Scowan felt it also, and from that moment he would thenceforth consider himself as my father and would fulfill the obligations of one to their fullest extent." Despite the beginning of their relationship, she was also able to claim the respectability of a genteel wife by claiming that she fulfilled all of the duties and the responsibilities of one. What's really interesting to me here is that Butterfield's statement of seduction is the first mention of seduction. Previous accusations made her out to be a sexual predator instead of Scowan. But rather than deny any sexual relationship between herself and Scowan outside of the ties of even common law marriage, she instead chose to begin her defense with this seduction narrative where she openly admits to losing her virtue. It's a strategy that worked, and it won her a huge amount of public support and empathy. After her trial, her character was viewed in a completely different way. The verdict of not guilty was even met with loud cheers and chaotic celebrations in the street outside. This performance of virtuous gentility played upon a masculine desire to protect the ideal of the submissive gentlewoman, and meant that the jury, in choosing to see innocence rather than guilt, could reinforce this model of gender relationship over the alternative possibility of a woman exercising morally corruptive power over men, and in this specific instance, having the power to overthrow the security of the domestic home through murder and potentially adultery. To find a woman who appeared to be moral and submissive, and who represented all of the fears that society placed upon their daughters, guilty, was so anxiety-provoking, it likely felt more comfortable and correct to find her innocent. The following trial reports now wholly presented Butterfield as an ideal woman. The General Evening Post demonstrated how her beauty and perceived delicacy were linked to impressions of her innocence. Writing that Miss Butterfield, says a correspondent, is one of the prettiest women in England. She appeared to really feel her situation, but wore a decent firmness in her countenance during the trial. The heat of the place being intolerable, she was indulged with a chair in which she occasionally rested during the remainder of the day. She was even held up in the Ladies' Magazine as an exemplar to other genteel ladies, and also as the living embodiment of the fiction they frequently published. Where before her trial she had been tarnished with the negative associations of sexual profligacy and the fear of maidservant turned criminal, when she harnessed the ideology of the seduction narrative and the character tropes of dutiful femininity, she was elevated by association with this ideal. What I believe this case shows us is the power of wifely ideology and female delicacy as cultural ideals at this time, and it demonstrates that the inherent fragility within this ideology could be harnessed by women who found themselves threatened by association with its opposite. Disgrace or suspicion could be camouflaged by utilizing the language, stereotypical narrative plots, and the imagery of feminine duty, and this allowed far more flexibility for women to negotiate and defend their own reputations and virtue in the courtroom. Thank you very much.
Mhm. Thank you, Amy. That was a fascinating talk. I was really sort of drawn by the sort of the ideas that you sort of explored in relation to sort of Butterfield's case in relation to the sort of construction of self-narrative, the seduction narrative, her harnessing the imagery of a respectable wife. I think that's a really fascinating way of drawing out those sort of fictive narrative forms in relation to this particular case. So thank you very much for that. Fourth and final speaker this evening is Melissa Ganz, and the title of Melissa's paper is Legal Terror and Popular Violence, Reimagining Justice in the Heart of Midlothian.
Thank you so much, Paul. And thank you as well to all the entire BARS organizing team, and especially to Sarah for putting this panel together. So I do not have a PowerPoint, so I'm not going to be sharing my screen. It will just be me. Sir Walter Scott's The Heart of Midlothian is permeated with scenes of crime and punishment. The novel begins with an account of the arrest of Andrew Wilson and his partner George Staunton, or Robertson, as he is known until late in the text, for robbing the collector of the customs at Pittenweem. Shortly afterward, we learn of Effie Dean's detention on a charge of infanticide. Fears of mob violence at Wilson's execution prompt indiscriminate shooting on the part of the city guard, followed by the mob's retaliation and public lynching of the captain of the guard, Porteous. Effie's death sentence, by contrast, is commuted to 14 years banishment after her elder sister Jeanie makes her way from Edinburgh to London to appeal to the mercy of the sovereign. Yet Effie remains an outcast, and the legal executions and popular violence continue. The final volume chronicles Meg Murdochson's public hanging, a mob's deadly attack on Meg's daughter, Madge Wildfire, and the death of Staunton at the hands of his own son. Through these fictionalized accounts of criminal cases from early 18th century Scotland, Scott highlights the limits of both legal punishment and extra-legal violence, contributing to debates about criminal justice that preoccupied jurists and philosophers in his own day. Critics have long noted Scott's interest in crime and punishment, but they have reached strikingly different conclusions about the problems Scott depicts and the solutions he offers to them. Here, Dolan argues that the novel criticizes an outmoded infanticide statute, as well as excessive legal formalism, but otherwise aligns itself with the normative institutions of law and religion. In Dolan's view, the novel does not provide a radical critique of the citadel of Scottish law. Rather, the text is written from within this discourse. Julia Simon Kerr, by contrast, highlights the significance of Jeanie's refusal to lie under oath to save her sister's life, arguing that through Jeanie's heroic actions, meaning her walking all the way to London from Edinburgh, Scott rejects the practice of pious perjury used by English jurors to correct the law's severity, forcing readers to confront larger problems with the legal system. Leland Monk argues that Scott looks beyond formal institutions of justice and holds up the carceral dimensions of the middle-class family. In this reading, Scott shows the need for individuals to cultivate a Foucaultian self-discipline in order to overcome the problems presented by Scottish legal practices, mob violence, and regal authority. Other scholars suggest that Scott looks to divine justice and God's agents on earth, especially the Queen and the King, to maintain order. So, for example, Ian Ward embraces this view, arguing that the pivotal character in the realization of providence and justice is the Queen. And Tara Gosha-Wallace, for her part, argues that the novel underscores the problems with the royal prerogative of mercy, but shows that the sovereign's right of mercy, however capriciously or ineffectively exercised, trumps a subject's arrogation of that right. In this talk, I build upon Simon Kerr's reading of the novel's critique of England's draconian criminal law and Wallace's account of the value and limits of royal mercy, while situating the novel more specifically in the context of late 18th and early 19th century debates about penal reform. In doing so, I revise our understanding of Scott's treatment of criminal justice while intervening in discussions about his views of Scottish national identity. Through his account of Wilson's and Effie's cases, I will argue, Scott critiques mob violence as well as the retributive nature of both the Scottish and the English penal systems. These cases show the need to devote greater attention to individual motives and intentions in assessing guilt and responsibility, and shows the need to incorporate mercy and forgiveness into the law. Yet, while Scott demonstrates the importance of mercy, he underscores the limits of the royal pardon, which proves too arbitrary and unreliable a remedy, and fails to address larger problems with the penal system. The novel instead shows the need to reform the law to allow for punishments that promote rehabilitation. We begin to see the benefits of this approach in Scott's account of the former outlaw James Ratcliffe. This approach complicates readings of the novel and of Scott's novels more generally that highlight his nationalistic celebration of Scottish institutions over and above and opposed to English institutions. In this reading, in my own reading, Scott suggests that the penal laws of both countries stand in need of reform, and he uses fictionalized cases from his own nation's past to offer a model for the renovation of criminal justice in Britain as a whole. So first, very brief review of the debates about criminal justice. Many critics allied the distinctions between Scotland's and England's legal systems, and thus it is helpful to review them here. The 1707 Act of Union provided for a unified legislative body, the Parliament of Great Britain, but with a few exceptions related to matters such as trade and commerce, the Act did permit the Scots to retain their own independent and distinct legal system. And thus we have England and Scotland developing distinct bodies of criminal law. The penal laws in England were notoriously harsh. Over the course of the 18th century, in response to fears about a perceived rise in crime, legislators passed a growing number of capital statutes known as the Bloody Code. The number of crimes punishable by death increased exponentially in this period, from about 50 in the late 17th century to more than 200 in the early 19th. English officials did mitigate these punishments in practice by the regular use of judicial and executive pardons. Scotland relied on common law more than statutory law, but some crimes, like infanticide, were still regulated by statute in this period, the period in which Scott wrote. And Scottish jurists, while more discretionary in their use of the death penalty than their English counterparts, were not averse to imposing the full severity of the law. These developments sparked heated debates about the nature and ends of punishment in both England and Scotland. Thinkers like Martin Maiden and William Paley defended the Bloody Code, arguing that the threat of capital punishment was necessary to deter crime. But in the last few decades of the 18th century, jurists and reformers, including John Howard, Sir William Blackstone, Sir Samuel Romilly, and Jeremy Bentham, sought to replace the death penalty with punishments that would reshape criminals' minds. Blackstone and Howard, for example, drafted the 1779 Penitentiary Act, which authorized the government to construct 2 penitentiaries in London and to experiment with terms of solitude and hard labor instead of hanging and transportation. In a series of speeches, Romilly famously urged legislators to act upon this plan, and Bentham put forward a proposal for a penitentiary known as the Panopticon, which sought to use pervasive surveillance to modify behavior. These proposals reflected a fundamental shift in thinking about responsibility. Reformers privileged nurture over nature and environment over heredity, maintaining that those who committed crimes were not irredeemably evil. For this reason, they urged lawmakers to replace punishments grounded in retribution with those founded on rehabilitation. Scottish thinkers also reflected on the nature of and justifications for punishment, though they emphasized retribution more than deterrence and rehabilitation. In Historical Law Tracts, published in 1758, the jurist and philosopher Henry Home Lord Kames offered a broad account of the development of law from the pre-civilized past to the present day. In his first essay on criminal law, he crafted a narrative of progress and change, describing a shift from savage societies in which individuals retained the right of punishment and frequently acted on their desire for revenge to civilized societies, including that of Scotland, in which the magistrate assumed the right of punishment. There perhaps never was in government a revolution of greater importance, he explained, than this shift to contain the natural passion of resentment. A great advantage of this shift was that revenge was kept within the strictest bounds. Adam Smith offered a similar account, as did Kames's friend, protege, and jurist, a fellow jurist, Alexander Fraser Tytler, Lord Woodhouse Lee. As these thinkers saw it, the natural measure of punishment was not utility, but was rather the feeling of resentment excited in an impartial spectator. The foundation of criminal law, Woodhousley stated, is retributive justice, that great principle which regulates the redressing of wrongs and the avenging of injuries. This did not always mean inflicting the harshest penalties. Woodhousley noted the barbarity and absurdity of many of the penal laws of the most enlightened nations, including, and especially that of England, cautioning against enacting overly severe laws in which punishments were out of proportion with the offenses, meaning the feeling of an impartial observer. Scottish thinkers then agreed with the English informers insofar as they viewed England's bloody code as excessive and unjust, but they criticized the law on different grounds and put forward different theories of punishment. An advocate and judge, as well as a successful writer, Scott was keenly interested in the nature and limits of criminal justice. He was admitted to the Bar of Scotland in the summer of 1792 and maintained a distinguished legal career alongside his literary work. He was familiar with many of these discussions. In 1814, for example, he published a series of essays supporting Romilly's proposed reforms in the Edinburgh Annual Register, specifically targeting the English code. But Scott did not direct his criticism only at the laws of England. He remained troubled by Scotland's violent past and worried that the propensity for revenge continued to plague his own country. He highlighted this problem in a review of Robert Pitcairn's Trials, which appeared in 1829 to 30, so around the same time as the Magnus Opus edition and revised edition of Hart Midlothian. At the same time, Scott expressed concerns about attempts to use excessively harsh punishments to curb such passions. And Scott developed these ideas in his fiction, and today I'm going to focus in particular on The Heart of Midlothian. In this novel, Scott shows a keen understanding of the problems that preoccupied English reformers and Scottish jurists alike. Although the novel is set in the early 18th century, it serves as a commentary on problems still current in his day, as well as our own, how to reconcile the need to curb lawlessness and violence with the need to reform the criminal law. Through Wilson's and Effie's cases, Scott contributes to the cause of the penal reformers, highlighting the limits of retributive justice, while drawing upon a long-standing interest among Scottish jurists and philosophers in the historical development of the law and implicitly acknowledging some progress on his own nation's part. He shows the need to continue to work for legal change. Just societies, he suggests, balance the desire to maintain law and order with a commitment to rehabilitate offenders. And in the interest of time, I'm going to run really briefly through a couple of examples to give you a sense of the evidence for these claims. So Wilson's case underscores the practical and ethical problems with a rigid, unforgiving penal system. We do not gain direct access to Wilson's point of view, but the omniscient narrator reveals the circumstances surrounding Wilson's crime and the motives that prompted, both of which undermine the imposition of the death sentence. So the narrator describes Wilson in largely favorable terms, often and repeatedly alluding to the compassion and sympathy that is evoked on the part of the public when he and Robertson are sentenced to death. And they are sentenced to death because, the narrator explains, a severe example is judged necessary, but the penalty seems out of proportion to the offense. He's engaged in an illicit smuggling scheme, and then he robs the collector of customs in order to recompense himself for what he feels he is owed. So death in exchange for robbing. The penalty seems out of proportion to the offense, the novel suggests, and the judgment of the community counters that of the vindictive state. Scott further criticizes the retributive underpinnings of the penal system through his account of Wilson's execution. So Porteous uses exquisite torture, putting in excessively tight handcuffs on Wilson. Your cruelty is great, Wilson tells the vindictive captain. You know not how soon you yourself may have occasion to ask the mercy which you are now refusing to a fellow creature. May God forgive you. In instances like this, as well as the exhortations from the teacher and minister Reuben Butler, Scott juxtaposes the secular vindictive law with that of the a divine law, and suggesting the need for mercy, which the secular legal officials withhold from this criminal. And ultimately, there is the mob violence, the public lynching of Porteous in response to his cruelty. So vindictive behavior and violence, there seems to be a cycle here. It really breeds more vindictive and vengeful behavior and violence. And in that episode, as in Wilson's execution, Scott blurs the distinctions between the criminals and the police, like the self-righteous robber whom Porteous executes, and the members of the mob who take his own life. Porteous puts his desire for vengeance above his supposed commitment to the rule of law. Scott reworks the story of the Porteous riot from 1736 to offer lessons for his own day. In showing the need for mercy, the novel echoes the concerns of England's penal reformers, as well as Kame's sense of the dangers of men's unregulated passions. But unlike Kames and his fellow Scottish thinkers, Scott suggests that the law does not adequately check men's desire for revenge. And we see further examples of this problem in Effie's trial for infanticide. At the age of 17, Effie is arrested for presumptive murder under a 1690 statute that deemed a young woman guilty if, after concealing her pregnancy, she could not account for the whereabouts of her child. In this case, too, Scott shows the law pays insufficient attention to the circumstances of each case. The legislature's desire to deter young women from killing their offspring results in a grave injustice. As we eventually discover, Effie had no hand in the disappearance of her child. She also did not completely conceal her pregnancy. She actually did reveal that very important fact to the two key witnesses who refused to come forward, her seducer, and then the woman, Robertson's friend, who aids Effie during her birth. Effie's plight reinforces the dangers of vengeance on the part of both the individuals and the state. And in the interest of time, I'm going to skip over some of the side-focused discussion of the infanticide episode to suggest a solution then that Scott offers here. Through Jeannie's lengthy journey to London to appeal for a pardon for her sister, she refuses to lie under oath. That would be the equivalent of taking the law into her own hands, just as the vindictive mob did. So through her lengthy journey, Scott shows the difficulty, but also the necessity of resorting to legal channels to rectify unjust laws, while suggesting the inadequacy and unreliability of the sovereign's mercy. So it's very difficult and unpredictable whether or not Jeannie will in fact get this pardon from the Queen. In the end, she does. But this is certainly not a reliable means of rectifying injustice. Jan Melissa Schramm contends that Scott's representation of the amelioration of injustice is restricted to individual cases. In her view, as the narrative moves towards its just resolution, following Jeannie's successful quest to preserve her integrity, Scott abandons calls for more widespread reform. However, Scott in fact reminds us by the timely viewing of another legal execution, that of Meg Murdochson, and the public lynching of her distressed daughter. Jeannie witnesses both of these while traveling back to London. Through these episodes, the novel underscores the larger problems that Effie's pardon cannot solve, and thus reinforces the limits of a penal system that relies upon pardons to modify strict laws. That's famously England's own system. What the novel ultimately suggests, like reformers such as Romilly and Bentham, Scott implicitly holds up legal change as the answer to the problem of crime and violence plaguing British society. Some punishment is necessary. The novel does not condone Staunton's, Effie's, or many of the other actors' illicit behavior, but the vindictive legal system, he suggests, also needs to be reformed. Scott gestures towards such reform in his account of Radcliffe's transformation, where Effie and George Staunton's guild eats away at them without producing real change. Radcliffe's reformation proves lasting. When Robertson and his friends storm the Tolbooth prison, Radcliffe wisely, back at the beginning of the novel, Radcliffe wisely decides to remain in the prison. And in return for his good behavior, he is given a chance to move from outlaw to turnkey. He eventually rises to be captain of the Tolbooth. At first, he straddles the line between the criminal and the police, yet eventually he gives up his criminal connections. Although he continues to entertain young men with stories of his extraordinary feats in the way of robbery and escape, he lives and dies without resuming his original vocation, otherwise than in the narratives over a bottle. In Radcliffe, Scott shows the possibility of change if individuals are given the opportunity for lawful employment and rehabilitation. Thus, in the end, Scott seeks to defer both to deter crime and to underscore the importance of penal reform in both England and Scotland. While critics have pointed to Scottish law as a source of uniquely nationalist pride, Scott does not simply hold up Scottish law over that of England. While he implicitly agrees with his fellow Scots about the problems with England's penal law, a system of harsh statutory punishments ameliorated on a case-by-case with pardons, he also criticizes these thinkers' faith in retribution as the foundation of punishment. Like the English reformers of his day, Scotch reaches toward a more merciful legal system that provides both real justice and rehabilitation for offenders. Thank you.
Thank you, Melissa. That was a really rich sort of paper and reading of Scott. I think I really enjoyed the way that you sort of explored the way that Scott, sort of in the novel looks at the aims, methods, outcomes, and the ethical dimension of the penal system, and sort of teases out those ambiguities between the relationship between sort of rehabilitation and retribution that lies often at the heart of some of these conversations that we've had this evening. I'd like, if that's okay with the panel, to ask the panelists to turn on their videos. And I think that the best thing to do is to open up to audience questions. And of course, if any of the panelists have questions for other panelists, then perhaps we can pose those questions as part of the conversation with the audience. So turning to the audience now, if anybody has any particular questions they'd like to ask any of the panelists, please raise your hand, or we've had a few questions posed in the chat. If no one would like to come in first, then I'm going to turn to the chat questions. Okay, shall we start in that case? Can I start with a question from Regina Hewitt? Regina, would you like me to read out your question, or are you happy to pose the question yourself?
Oh, I'm happy for you to do it. Thank you.
Fantastic. Regina's question, and I'm reading straight from the chat here. Mention of being, quote, beyond English coverture in France makes me curious about law in France. Was there coverture or equivalent in France?
Okay, I'm not going to claim to be a French legal expert here. The honest answer is I don't know. I think there may well have been an equivalent, and I shouldn't think for a moment that French women were truly equal in their marriages, but I do not have, as far as revolutionary marriage is concerned, I do not have chapter and verse. I'm not a revolutionary or indeed a French legal specialist. There may well be somebody else in the room who can speak to that, who is the expert. I don't know, but not off the top of my head. I can't answer that, I'm afraid. I'm sorry, that's a disappointing first answer, isn't it?
Well, it opens up lots of lines of research. Thank you.
I believe under the Napoleonic Code, it changes under the Napoleonic Code. Revolutionary marriage exists, and I use my source was Suzanne Deson, The Family on Trial in Revolutionary France, which is an excellent book, and I do recommend it. Is that the revolutionary marriage exists for a very short period of time, and I found it really, really difficult to get detail on it. I couldn't find, what I really wanted was the form of words for a revolutionary marriage, and I could not find that. And then that is supplanted by the Napoleonic Code, and my understanding of it is that the Napoleonic Code is very conservative, and it clamps down on things. So I would venture a guess that if it's not there, then there's something very, very similar to it, and certainly under Napoleon. James Treyer's, Melissa's put something in the chat. James Treyer's book on marriage in France would help you. Yes.
Oh, thank you then to Melissa as well.
Yes.
Fantastic, thank you. We've had a few questions from Gary Kelly. Gary, if you're with us, feel free to unmute yourself and pose your questions, or I'm happy to read those out on your behalf.
Yeah, go ahead. Just take one of them. I tried to give everybody a question. I'm sorry
sure.
if it seemed just.
Well, I'll start off with one at random then, because it's a very good question. Should we start with your most recent one in that case? If I can just find that. Question from Gary Kelly. Gary would like to know, in response to Sarah's paper, in terms of that concept of the breakdown of the dichotomy between the private and the public. Gary sort of questions to what extent that might be viewed as a dialectic as much as a sort of opposition. Forgive me, Gary, if I haven't phrased that precisely in the correct terms.
No, I think that's a point well made. Thank you. I think, yeah, it's conventionally described, the term that's used is a public-private dichotomy. There's definitely a dialectic in each of them constitutes the other, right? So they're inherently dialectical. And clearly there are lots of crossovers with married women operating in both realms. What I'm trying to sort of unpack is what this, at the level of ideology, what this represents, and what sort of awesome, I think, what other romantic women writers are contributing about trying to challenge that idea. Yeah. I actually really liked your earlier question. Sorry, I can jump in. The one about that idea of using the self-reflexive modern subject, because I think one of the things that has come out across the papers, I'm really interested in, is looking at the role that women's legal experience plays in the development of the conceptualization of that subjectivity, especially in the 18th century. And I'm interested in the memoir and the published autobiography as well, and then its relationship to the novel. And I think one of the things that came out across all the papers is looking at both the idea of the case and the novel as sites for the interplay of both of those things. I'll stop talking now.
Fantastic, thanks, Sarah. Got another question here. I think this one is primarily for Alison, and it's from Lisa Gaston. Lisa, would you like to pose your question on video, or shall I read out your question?
I can pose it.
Great,
That's
thank you.
Fine. Hi. Yeah, so my question's for Alison. I really love what you were saying about coverture as this kind of central to how we can read and understand female author texts of the period. And when you're talking about coverture and The Wanderer, I was thinking a lot about Cecilia. So my question is, does Burney's treatment or use of coverture in The Wanderer change from her earlier works? You can speak to any, but I was thinking mainly of Cecilia. I was thinking of, is the subversive potential of that earlier text with the name clause and the conditions of the will similar to The Wanderer, or is it ultimately foreclosed? So I know I've read different critical takes on how radical that text may or may not be. So I'm just really curious of your take on it. Thanks.
Hi, yeah, that's a really great question, and it's one that I think Melissa as well can input into. Certainly, I do think that there are issues relating to coverture in Cecilia, and it was one of the sadnesses of doing a thesis is that there's so much you have to cut out. I could easily have put a whole chapter in on a sort of bigger chapter in on Burney, and I think having an awareness of coverture and how it functions, and specifically how the different bits of coverture function, is important, and you begin to then pick things up that you wouldn't otherwise pick up. So, for example, I was talking about the idea of the portion and the equivalence of the portion with the wife, and what the loss of personal property meant under coverture. And I think in Cecilia, actually, the thing that really strikes me about Cecilia is that she loses her land. Now, the thing about land under coverture is that the husband did not control it. It remained the wife's property. She couldn't sell it, and the husband was entitled to any rents or profits that arose from that land, but he couldn't dispose of it. And if he died, then the wife kind of regained full ownership and control of the land, and she could do what she wanted with it. And I think one of the things that kind of leapt out from Cecilia at me when I'd done the research on coverture was that particular point. And I think Burney is doing that deliberately. It's in there, and it's something that an 18th century audience would undoubtedly, I think, have picked up on. And it's something that we don't, because we've forgotten about coverture. Coverture has just disappeared. It's not something that we engage with at all. But I don't know. I know that Melissa has in Public Vows has written on Cecilia, so I don't know if she's got anything else that she'd like to come in with on that?
Yeah, I guess I will add that I think I see Bernie as getting actually more subversive as we go along, and especially I think useful here maybe to connect back as well with some of the other discussions of Gary Kelly in the chat and Sarah's paper as well. If we think about the very ends of the novels, what happens with the accounts, the narrative accounts of the really at the level of more of a metaphorical, symbolic level, the descriptions of the characters, because they all end up married in many ways. And in Cecilia, as Allison notes, Cecilia actually voluntarily gives up the bulk of her property. But I think it's really telling, actually, this would be useful for you as well, Allison, at the very end of The Wanderer, even as she gets married, and so her legal personhood technically gets covered over, but there's that great final paragraph where the narrator emphasizes it summons back up her character as a wanderer, as Gary Kelly noted in the chat, this figure of her when she's actually independent and not covered over. So it seems like Bernie wants to have it both ways. The Karen, this person, legal technically disappears, and yet she's reminding us of that great literal and figurative freedom that she had earlier in the novel.
Yeah, absolutely. I think with coverture both as a piece of law and as it appears in the historical record and as it appears in literature, there's very often this kind of cognitive dissonance that surrounds it, and it's capable of kind of embracing opposites and holding them at the same time. Yeah, absolutely.
If I could just jump in with an additional question to kind of add on to that. I was sort of wondering about if there's kind of a similar progression that you see in parallel from other female authors in terms of the way that they are, discussing coverture and kind of attempting to, really, really emphasize that, erasure of the woman's personhood, through marriage and sort of an attempt to reclaim it. And I was wondering how much that, this idea of the ethic of care in marriage is a way of appeasing that cognitive dissonance, where marriage is obviously a positive thing, but also it's very much a loss of kind of the legal selfhood, or if it's a way of kind of mitigating that loss. I know that's a very vague question, but yeah, I was just kind of wondering about all of that, really. That's sort of for Alison or Melissa or Sarah or whoever.
I was going to say that sounds like a question for Sarah.
So, Amy, do you mean look at thinking about care as a benefit of marriage that offsets the loss of legal selfhood? Is that what?
Yeah, as a kind of that in order you kind of, if you're following or if you're going for the ethic of care in your marriage contract and in the suitor that you're choosing to marry, if that is your kind of means of offsetting the loss of selfhood and personhood. And I wonder if that's a way of dealing with the loss of selfhood and kind of appeasing that cognitive dissonance that comes with it.
Yeah, potentially. Although I think the lack of value that's externally attributed to care would kind of confound the possibility of that in some ways as well. I guess it depends on an idea of subjectivity. If you yourself could feel that sense, you could do it internally as sort of internal sense of selfhood. But if you're looking for kind of external validation, I'm not sure you're likely to find it if you're kind of identifying with an ethic of care as what you're getting in relation to the loss of personhood. Okay. Could I ask a question to you, Amy? So I thought your paper was fascinating. And I think that idea of that interplay of the sentimental novel into the 18th century courtroom is just fascinating. I think your research was amazing. One of the things I was going to ask you was, I noticed that one of the engravings of Jane Butterfield was from the Ladies magazine. Mm-hmm. Was there could you talk any more? This might be outside what you've done, but have you thought any more about that sense of how this case was represented in the Ladies magazine and whether there were any kind of readership sort of engagement with that? I'd be really interested.
So there was a massive readership engagement with it. I think so. Initially, they reported the trial, which they did for quite a few other women. So one of my other case studies, Margaret Rudd, who's the same year, she's got a lot of similarities with Jane Butterfield, and they covered her trial as well. But Jane Butterfield's trial was so popular that then kind of in the, I think it's the August, no, it would have been the September publication, they made an announcement at the front that they were basically taking out one of their serial fictions in order to put in more material about Jane Butterfield. And they published, so they did, because quite a few sort of like letters and various little pamphlets and things that claimed to be written by people who knew Jane Butterfield came out after the trial and was sort of, celebrating what a wonderful woman she was and really attacking William Scowan's surgeon for, persuading Scowan that she had poisoned him, and saying that he was a terrible professional and didn't know anything because how could this wonderful woman have poisoned this man, and also attacking William Scowan's nephew James ended up inheriting all of his property, and there was a lot of criticism of him, saying that now that Jane Butterfield had been found not guilty, she should be given the £20,000 that she was initially willed in the original will, before Scowan changed his mind. So there were quite a few letters of that sort published, or like kind of commentaries published of that sort in the Ladies magazine. There was the piece that I quoted from was kind of like it's like a long commentary that basically explores how Jane Butterfield's story is a perfect example of how being too beautiful can get you into trouble and lead you to being seduced and basically land you in precarious situations such as the one that she's landed in. So yes, she was very, very popular, and there was an awful lot that was then published about her in the Ladies magazine for, I think it's the September issue and then the October as well.
There's been a couple of questions posed by Gail Stanley in the chat box. I think they're both fantastic questions. Gail, would you like to ask your questions directly to the panel?
I think it probably helped me if you ask them for me. I'm only just starting to study this, so I really appreciate this panel. Thank you.
Absolutely. I'll read out your questions in turn then in that case. So Gail's first question to the panel is, and I'll quote from the chat box. We can see how coverture and other legal issues were being engaged with and reframed by writers. Was there much awareness or pushback from the original audience and society?
Shall I start? Yeah, I think that's going to depend on who is doing the writing. I think if it's Mary Wollstonecraft, yes, there was. However, I think part of the reason why women are writing and using, why there is this history of metaphor, why you have this equivalence of portion, why you're talking about the disappearance of women, one of the reasons that women are using these metaphors is because they are subtle and because they kind of need to get them in under the radar. I'm not sure that any you have to, I don't know if there's anybody who's got more experience than me about audience reaction and audience pushback on the panel, but certainly I would say that's one of the reasons why it is subtle and it is not obvious. And also there is also the perennial problem that women writing about love and marriage is always, even today, seen as being a very low form of art and something which, the intelligentsia or certainly the male elite do not need to trouble themselves with. So in a sense, perhaps you have women speaking to women, and there is a sort of encoded conversation that is going on between the novelist and her readers, and they're picking up on things which perhaps a male reader might not. I don't know. That's just a thought.
Yeah, I'll just pop in quickly here. So I think this is a great question, something that really interested me as well when I was looking at the way that 18th century novels were engaging in debates about marriage law. And so I mined the periodical databases, the newspapers, Echo, all of the kind of treatises, pamphlets that were published at the time. So I think it, as Alison was suggesting, it really varies, in what text and what issue, but that's an amazing resource to try to get a sense of what the discussion is like out there in the larger public sphere. And the reviews of novels. I have to say the reviews weren't terribly helpful for me because at the time they tended to be primarily summaries, lengthy excerpts, quotes, direct quotes from the text, and then not tons of a sense of interpretation. But those are all great resources, I think, to use to think about how these novels and other texts are in conversation with the larger public about these questions.
Fantastic. Thank you, Melissa. And I'd really like to ask Gail's second question as well, if that's okay, if the panelists are okay to hear that. Gail also asks, and I'm quoting again from the chat box, Austen also maybe gives examples of coverture working the other way and men suffering from being married for money. Mr. Bennet, Mr. Rushworth, and Charlotte making her own compromise in Pride and Prejudice. I'm assuming, Gail, that the question there is perhaps more broadly to what extent are male characters in Austen's fiction depicted as perhaps sort of also victims of coverture? And correct me if I've misinterpreted that question.
Yeah, I was just sort of wondering or suggesting that maybe, Jane Austen's really quite opening it up because she's looking at the whole bad effect of it on society, and she's like, the mistress of describing unhappy marriages and difficult compromises that people have met and the very different consequences they have. Mr. Bennet's consequences quite different to Mr. Rushworth's. Thank you for those answers. I really appreciate.
Fantastic. Thank you, Gail. Do any other audience members have any questions? I don't want to test the patience of the panelists too much, but I'm reluctant to wrap up, really. It's been such a fascinating conversation. Okay, perhaps one final question from Gary Kelly. I'll read this out on your behalf, Gary. Quick question. So who's more radical on coverture, Burney or Wollstonecraft?
I think the issue for Wollstonecraft, unfortunately, is Wollstonecraft gets very, very cross and very, very angry about coverture. But what she doesn't manage to do in either of the novels is to provide an alternative. In Mary, the alternative to coverture is that you have to die. And in Maria, I mean, is it this kind of female utopia where we all live together and we're all? I'm not convinced. So in some ways, Wollstonecraft is angrier and therefore more radical, but equally, I think Burney offers us a way to live within the current restrictions, or a reframing of the current restrictions. And I think that is potentially more radical. I don't know.
Thank you,
the
Alison.
alternative is for Mary Wollstonecraft to shack up with whoever you want, it says in the chat. Yes, possibly. But that doesn't really work, does it? Because she gets married to Godwin anyway, so.
That's wonderful. I've noticed the time we've run, well, not run over by a quarter of an hour, because I think I probably speak on behalf of the audience. I've been sort of swept along by the sort of rich and fascinating detail in the papers here this evening. Are the panel happy for us to draw things to a conclusion? If they are, I would like to take this final opportunity to thank Melissa, Amy, Alison and Sarah for being with us tonight and sharing their expertise with us. So a virtual round of applause for our panelists. Thank you.